Guns, firearms and divorce in Illinois. In America, you have a right to own a gun under certain federal, state and local conditions. When you begin a divorce in Illinois, those rights are also subject to the divorce decree. Illinois courts classify property as marital or non-marital. A gun bought before marriage is non-marital and remains with the original owner as long as they can prove when it was acquired. A gun purchased during the marriage is generally marital property unless it was bought with separate funds, inherited or received as a gift. An attorney can gather evidence to support the proper classification. To lawfully possess a firearm in Illinois, you must hold a firearm owner's identification card, FOID, so the court will only award guns to a spouse who has a valid card. When both spouses have cards, the guns may be split. If only one does, that spouse usually receives them. Illinois divides property equitably, so judges aim for fairness rather than an exact split. Spouses can agree on the value of their guns or rely on testimony. The spouse who keeps the firearms should compensate the other for half of their marital value. A skilled lawyer can ensure valuations are reasonable and the division is fair. Gun owners with children must follow strict storage rules. It is unlawful to leave a firearm where a child under 14 without a FOID card could access it and then cause death or great bodily harm. Having a gun in a home with a young child generally requires the other parent's consent. There are exceptions when the gun is disabled by a locking device, secured in a locked container or kept in a location a minor cannot reach, but you must show that these safety measures are in place. If the other parent objects, a judge will decide based on the best interests of the child. A knowledgeable attorney can help ensure compliance and protect parental rights. Divorce disputes sometimes lead to emergency petitions for an order of protection, particularly when guns are involved. Judges typically grant an interim order that can last up to 2 years, and ownership of a gun may be enough for a judge to issue it. A respondent under such an order cannot possess weapons. Their firearms must be surrendered to someone with a valid FOID card, and their own card is handed over to local law enforcement and sent to the state police. Violating the order or having certain convictions within the past 5 years can lead to denial or revocation of a FOID card. A diligent lawyer can explain how these orders affect your gun rights. Practical strategies can reduce conflict. Moving yourself and your guns out of the marital home helps avoid police questions about firearms. Instead of resorting to an order of protection, a spouse can seek temporary relief that restrains the other from possessing guns until the case ends. Courts often grant such requests when children are involved. Selling the guns eliminates them from negotiations. Firearms not in possession cannot be included in the marital settlement. Without guns present, your spouse is less likely to insist on clauses about firearms. After the divorce, there is usually no duty to inform the other parent if you acquire a firearm, but if children have access, you risk a Class C misdemeanor with a minimum $1,000 fine, which could support a change in custody. Consulting an attorney at a respected law firm can help you choose the best approach. The Law Office of Russell D. Knight, located at 1165 North Clark Street, No. 700, Chicago, Illinois, 60610, United States, can guide you through these issues. Call 773-334-6311 to speak with a lawyer who understands Illinois divorce and gun laws. This law firm focuses on family law, and you will speak directly with an attorney about your rights and options.